Well, this is part two, the second segment in my lecture on international humanitarian law. Let me say a little more about the sources of international humanitarian law. Of course, we have the classic distinction that we have in all of public international law between the treaties and customary international law. As I mentioned, there is a lot of history behind international humanitarian law. In the laws and customs of war existed before international law existed. And we've seen how we can go back as far as the Greeks and certainly to the Middle Ages. And the studies have been done showing that, this isn't just a feature either of Western cultures and civilizations, but that we have similar phenomena throughout the world in terms of the attempts to impose legal rules on armed conflict, and custom clearly preceded codification. There's an interesting distinction here with a related field of law I'm going to talk about in a minute, which is human rights law, because human rights law had no custom before the modern period. Human rights law was really viewed as being entirely domestic in nature. It wasn't about relations between states the way humanitarian law was. And so what happens after the Second World War in human rights law is that we start to codify the human rights law. And it's only later that we start to talk about customary international law. So the order is reversed a little bit. With human rights law, we have the codification of the rules in human rights law before we have the custom emerging. With humanitarian law, we have somewhat the opposite. So I've mentioned some of the treaties. I haven't referred to all of them, but there's a whole body of treaties, some of them general in application, and some of them quite specific. The main sources, of course, being the Hague Conventions and the Geneva Conventions for the two cities where the treaties were adopted, but reflecting a different focuses, as I've pointed out. There's a great deal of material on this, although there's not a great deal of law, of legal judgments. We have some recent material because we've had more war crimes prosecution, but it's not like a lot of law where we're constantly going in and out of courts to have the judges settle issues about the interpretation of the treaties. Most of the issues are settled by either at the bilateral level or through some sort of negotiations and through the subsequent practice of states dealing with the treaties. If you are looking for material to assist in understanding the treaties, many of them have some very authoritative, what are called commentaries. So the International Committee of the Red Cross, which is the body that is responsible for the kind of, what's the word to describe them? It's the international body that's responsible for the application, the dissemination, and to a large extent the enforcement of international humanitarian law, has published authoritative commentaries on both the Geneva Conventions and the protocols. They're all available on the website of the International Committee of the Red Cross. So if you were doing research into one of the Geneva Conventions, the fourth Geneva Convention, and you wanted to see something about Article 49, the starting point would be to find the commentaries of the International Committee of the Red Cross and to find the chapter on Article 49. Now, they first did that back in the 1950s, so it's a little out of date, but there are now some new commentaries that are bringing the material up to date. So that would be the starting point. There's also a very extensive and detailed commentary on the two protocols of 1977. And more recently, as I say, some of the provisions are interpreted and applied by the international criminal tribunals, but not most of them. Because most of the provisions of these treaties, if we take the 4 Geneva Conventions and the 2 protocols, we're talking about probably 600 distinct articles. And most of those are not war crimes. The violations of those articles are not war crimes. They're rules. They're rules about prisoners getting their posts delivered. and about religious observance in prisoner of war camps, and about penalties that can be imposed on juveniles in an occupied territory, and so on. And they don't have any reflection in terms of war crimes, which are reserved for the most serious violations of those rules. So some of those war crimes get interpreted, not all of them, and many of them, when you see the language, you'll realize that they're actually quite archaic, and we haven't had any case law on them. So there's for example, a rule that we have in the Hague Conventions about giving no quarter. Giving no quarter is, taking no prisoners. It's saying we're not going to take any prisoners. We're just going to kill the enemy and take no prisoners. And that notion is a war crime. It's in the Rome Statute. It's in other sources also of war crimes, but I'm not aware of any prosecution for it in probably since the Second World War, and maybe even before then. So for a lot of these provisions, we're not going to find a judgment. We're not going to find case law, but we will find authoritative commentary. And the commentaries are often based and rely to a large extent also on the practice of armies. So they'll consult what military manuals and so on in different countries have to say about the observance of the laws of war. And some of it gets quite theoretical in modern times, especially when we deal with international armed conflict, because there are so few countries that in recent decades have had any involvement in international armed conflict, in occupied territories and so on. So they don't really have any practice, they just have ideas. The other source, which is also of great importance, is customary international law. A problem with customary international law is, of course, it's not written down the way a treaty is, and we don't have commentaries on customary international law generally. We still don't have them for customary international law dealing with human rights, any sort of resource or source book that would set out what the rules are of customary international law and human rights. Well, the International Committee of the Red Cross decided back in the 1990s that it would be a good idea to prepare a study of customary international law. And for this reason, it had often been said prior to the 1990s that the Geneva Conventions were probably coterminous with customary international law, that they were in effect equivalent to customary international law. The reason being that essentially every state on the planet had ratified the Geneva Conventions. Everyone has ratified them. And so the argument was, even if the state hasn't, or even if the treaty technically doesn't apply, that it would be setting out rules of customary international law. But in 1977, when the two protocols were adopted, one dealing with international armed conflict, one dealing with non-international armed conflict, states were slow to ratify the treaty dealing with non-international armed conflict. And so the Red Cross said, well, why don't we see if we can demonstrate that most, if not all, of the rules in the protocols, and particularly with the second protocol, which deals with non-international armed conflict, why don't we see if we can demonstrate that those rules are customary international law? And so they prepared a study that was published in 2005 that goes through the rules. I think there are 160 distinct rules that it identifies as being rules of what are called customary international law, and there's a demonstration of it. Some of it is controversial, most of it is not. And those books, the Customary Law Study, is also available for downloading on the website of the International Committee of the Red Cross. I have in my laptop all of this stuff that I've downloaded, and you can do keyword searches. It's a fantastic resource. So now we come to the question of the relationship between human rights law and international humanitarian law, or the law of armed conflict. People are often confused also because the terms humanitarian sounds like human rights, and people who are not trained in this subject either think that they're the same thing, or they confound them, or they understand, they think that the humanitarian law is simply human rights law in wartime. It's a little more complicated than that. And what I want to do is explain to you what some of the issues are about the relationship between these two bodies of law. The first thing to point out is that the human rights treaties, although it seems clear enough that the main human rights treaties, when they were drafted, did not contemplate their application in armed conflict. They didn't really address it, except to say that states could suspend some of the rights in the treaties, to suspend the application of them if they were in the situation of war. And we call these the derogation clauses. We have them in the International Covenant on Civil and Political Rights, Article 4, and we have in the European Convention on Human Rights, Article 15. The European Convention on Human Rights even refers to war. Article 15 says that states can derogate from certain rights, but it says you cannot derogate from the right to life except for lawful acts of war. And so it was very explicitly contemplated. Article 2 of the European Convention on Human Rights sets out the right to life and provides for certain exceptions, but they're all peacetime exceptions. And then it seems the drafters may have had the idea that you could suspend the convention for lawful acts of war, suspend the right to life. So there are issues that have arisen. The first one is how to articulate that relationship if both bodies of law apply. So once you acknowledge that human rights law can apply in armed conflict, then the issue is what's the relationship between the human rights law and the international humanitarian law? The other difficulty is a jurisdictional one. It's if European states go to war, what's the application of human rights law? Of course, humanitarian law will apply. If there's a war and an army from Europe, well, let's take a concrete example. The British going into Iraq, invading Iraq in 2003. There's no doubt that the law of armed conflict applied to the British combatants in Iraq, and nobody would argue differently, and the British government wouldn't argue differently. They would acknowledge this and admit this. But they would dispute ferociously, and did, the idea that the human rights law, the European Convention on Human Rights, could also apply during an armed conflict. And so this is essentially a jurisdictional issue. It's not about the relationship between the two bodies of law, but it's about the application of human rights law outside the territory where a state's involved in an armed conflict. And I think that as a general rule, when we're outside the territory of Europe, the position of the European Court of Human Rights is that the European Convention will apply to the extent that a European country controls the territory in the context of a war. So the parts of Iraq that were controlled by the British were, according, I think the European Court of Human Rights decided this on a number of occasions, were in fact subject to the European Convention on Human Rights. And there were judgments against the UK for the conduct of its forces in Iraq, in the parts of Iraq that were occupied. Indeed, when the occupation regime was created in Iraq in 2003, it was a joint enterprise of the British and the Americans, who were the two main armies who fought the war in Iraq. And the Americans, of all people, made a decree that the death penalty could not be imposed in Iraq. And that was out of the concerns of the British, who knew that the death penalty prohibited in Europe, that they would need also to prohibit it in the territory over which they would have some control in occupied Iraq. We have recent examples also of the application of human rights law in armed conflict. In October or late September of this year, armed conflict broke out on the territory of Europe between Armenia and Azerbaijan, or between the state of Nagorno-Karabakh, which is inside Azerbaijan. It's this is all a remnant of the breakup of the Soviet Union. And since 1990 or 1991, part of Azerbaijan, inhabited largely by people of Armenian ethnicity, has been for all practical purposes an independent entity or independent state. In any case, fighting broke out there, and Armenia went to the European Court of Human Rights against first Azerbaijan, and then later, a few days later, against Turkey, because Turkey is supporting Azerbaijan and is also, of course, in Europe and a member of the European Court of Human Rights, for actions undertaken in the context of the armed conflict. So this is a situation where, of course, we don't have a final judgment of the European Court. The court issued an interim measures order not to violate the European Convention. What Armenia is contending is that the way they're waging the war is a violation of the European Convention on Human Rights. So that's there. We are in the zone of international humanitarian law as well. Hence, it becomes important to see if we can understand the relationship between the two bodies of law. Well, the issue first arose in a judicial sense before the International Court of Justice in the mid-1990s, when there was an application for an advisory opinion. It came from the General Assembly of the United Nations to the International Court of Justice about the legality of the use of nuclear weapons. And when it came to the court, there was an argument about which bodies of law would apply. And the anti-nuclear weapons states argued before the court successfully that human rights law applied, as well as, for example, humanitarian law. And they said that human rights law prohibited the use of nuclear weapons. And there they found some support in a general comment issued by the Human Rights Committee of the United Nations, which is the body that enforces the International Covenant on Civil and Political Rights. So what did the International Court of Justice do with this? It said, well, it said, it's true, it agreed that the International Covenant on Civil and Political Rights did apply in wartime. They pointed to the derogation clauses and said that was specifically contemplated that they could apply in wartime. But then they said, nevertheless, in the situation of armed conflict, international humanitarian law would be what they call the lex specialis, the special body of law, and the implication was that it would somehow displace human rights law, or that human rights law would defer to international humanitarian law, which was more specifically tailored for the context of armed conflict. I never liked that ruling. I remember quarreling about it and criticizing it at the time, because it was, I had been taught at law school this rule of interpretation, lex generalis, lex specialis. This is a rule that we apply all the time that people who haven't even been to law school understand, because it's just a rule of common sense. If I say to you, we're going to have the class from 10 o'clock till 12 o'clock. So the lecture will be from 10 to 12. Please be there from 10 to 12. And we'll have a break from 11 until 11:10. Nobody's going to be stupid enough to say, Prof, I don't understand what you're saying. You said we're going to have the class from 10 to 12, but then you said we won't have a class from 11 until 11:10. What is it? How can we do both? You would understand that I was creating a special exception to a more general proposition. And the idea of a rule of interpretation in just common sense, even outside of a courtroom context, is simply recognizing that if it's from the same person, they imply that one rule is an exception to the other. The problem is, as I've explained, human rights law and humanitarian law come from different places, from different sources. They may have some ideas that are common. They're concerned with humane treatment and so on, but they're not the work of the same legislator. And in my view, for example, the idea of humanitarian law, that it applies equally to both parties in a conflict, I don't get it when that applies to human rights law, because in human rights law, you have sometimes people who are acting lawfully, and they have a right to do certain things that people who aren't acting lawfully can't do. Just to give you an example, according to humanitarian law, we don't take sides about the conduct of the hostilities between the two parties, as long as they're fighting fair and they're not using prohibited weapons and they're not firing at impermissible targets and so on. But it's not the same in the human rights context. The use of lethal force under the European Convention on Human Rights is reserved to lawful authorities. The gangsters who are fighting with the cops can't say, well, the cops fired at us and we fired back and we respected the rules of armed conflict with the cops. The gangsters are acting unlawfully. The cops aren't. In principle, they're not. Sometimes they are too, but the principle is that there it's perfectly legitimate in our human rights context in peacetime to understand that the two sides are, one side is entitled to use lethal force, providing it's proportioned and so on, whereas the other side is totally prohibited from doing it. And what's the reflection of that in armed conflict? It seems to me that if one side is waging a war unlawfully, they're violating the right to life of the people they kill on the other side, regardless of whether it's lawful to kill people on the other side under the humanitarian principles. And there's some recognition of this in a recent statement issued by the Human Rights Committee of the United Nations, what's called General Comment 36, where they say that killing people in an unlawful war is ipso facto a violation of the right to life. Well, in general, I think what we find is that human rights law can very adequately govern most of the situations that we're going to encounter in an armed conflict. And so I would think that if the European Court of Human Rights proceeds to deal with the substance of what's going on in the conflict between the Armenian state, Nagorno-Karabakh is called Arzak, between Arzak and Azerbaijan, that it will find that it has the tools that it needs to do that within the European Convention. And it already has done that in judgments of 15 years ago or so, dealing with the conflict in the Russian sub-state of Chechnya. So, but we will wait and see if the law has evolved there and how that will play out at the European Court of Human Rights. There is one area where clearly human rights law is somewhat inadequate, and that's in the treatment of prisoners, because the human rights law has very specific rules about people who are detained. The European Convention on Human Rights in particular has rules on what is prohibited and what is permissible detention. And it doesn't make any room in the European Convention on Human Rights for detention where prisoners of war are concerned, for example, or civilian internees during an armed conflict. And probably they should have done it. It's a gap, it's an inconsistency, it's an incoherence. The European Court of Human Rights has corrected that in a recent judgment dealing with the United Kingdom, just saying that Article 5 of the European Convention would essentially defer to the prisoner of war rules that we have in the Third Geneva Convention. So let me just talk a little bit. I have some comments now on some of the issues that arise in the conduct of, in the course of applying international humanitarian law. Let me talk now about the principles that govern the conduct of hostilities. So this is the fighting. This is the battlefield. And I think probably the core rule when we're dealing with the battlefield governs the issues of targeting. What can be targeted? What can you fire on? And there's a classic distinction we make between the civilians and civilian objects and military objectives. It's prohibited to fire on civilians. It's prohibited to fire on civilian objectives unless they've lost that character or have some mixed character because they're being used for the purpose of the hostilities. But to the extent that they are not, they cannot be targeted. A military objective can be targeted, but not without limits. So the limits are a very vague notion that we have of proportionality. And proportionality means that you have to do what is necessary to achieve the military objective, but not beyond that. And that becomes particularly important when the targeting of a military objective will have consequences for civilians or civilian objects. The bombing of a city may be justified under certain circumstances because it's a military objective that you're targeting. But the likelihood is that there will be very significant damage. The term that is often used is collateral damage to civilians or to civilian objects. And so that has to obey stricter rules of proportionality. And the military that is doing the attack is expected to weigh up the interest, the value of the military objective against the damage that will be done to non-military objectives. I think that's, in a very general sense, the philosophy that's at work here. There's another notion that we have that becomes particularly important in a non-international armed conflict, and that's what we call the direct participation in hostilities. So we don't just talk, especially in a non-international armed conflict, about a distinction between combatants and civilians. In an international war, the combatants, first of all, they wear uniforms. They're supposed to wear uniforms. They're supposed to have little patches on their sleeve saying what country they come from and a little flag and all of that, so that they're identifiable, so that they can be distinguished from non-combatants. And the idea there is that that the other side then knows what they can shoot at and what they can't. But of course, and this is particularly true in non-international armed conflicts, that we have civilians who are, I mean, the classic example we give is that he's the farmer by day and the guerrilla fighter by night. He works in the fields during the day, and when it gets dark, he puts on his uniform and gets his gun, and he goes out and starts participating in hostilities. And there the rule is that he becomes a combatant and he loses the civilian protection when he's out there acting as a combatant, but not when he's a farmer during the day. Okay, and so this is this notion of direct participation in hostilities. There's been a big debate within the International Committee of the Red Cross that I think is still to some extent unresolved. The International Committee of the Red Cross about a dozen years ago published what it called guidance on the issue of direct participation in hostilities. And there it advanced the idea that even soldiers wearing uniforms could not be killed gratuitously, that clearly they are in principle a threat to the other side. But there are occasions, often frequent occasions, when you can capture the enemy without having to kill them. And people call this sometimes the kill or capture debate. And some of the military, some people say, well, no, it's about the status. So if it's someone wearing a uniform, you can kill them no matter what they're doing. You can kill them if they're wearing a uniform, if they're stone drunk, sitting around, they're no threat to you at all. They don't have a gun, but they're wearing their uniform. They're the enemy. You get to kill them. But I think the better view, in my humble opinion, and one that's more consistent with human rights as well, is that even soldiers have rights. They have a right to life, and they shouldn't be killed gratuitously. They can only be killed as is necessary. And these are these principles of proportionality and military necessity.